crazy. So I would love to see how a cross-examination would go, but looking at this and seeing all the motions that have come down so far, we're probably not even going to get there. If I had to put my money on it, I would imagine that we're not getting even close to hearing Lil Woody testify again. So we have tons of motions in this YSL trial that got filed yesterday, and we even have the state responding. The first one that we saw come down is from our guy DeMonte Kendrick, aka Yak Gotti, aka Mr. Doug Weinstein. They put this together asking for a mistrial, and we're gonna read and get into some of the details why they're asking for the mistrial. Excuse me. And some of the things that have been going on with the case that we're well aware of. All right, so let's go ahead and get into it. DeMonte Kendrick's motion for mistrial. Here we go. Comes now. DeMonte Kendrick, aka Yak Gotti, by and through his undersigned counsels, we know that is Mr. Doug Weinstein, and brings this motion for mistrial, shows as follows. We think that this case of this nature, we think that in all cases of this nature, the law has invested courts of justice with the authority to discharge a jury from giving any verdict whenever, in their opinion, taking all the circumstances into consideration, there is a manifest necessity for the act or the ends of public justice would otherwise be defeated. Yeah, they're saying we need to get the jury out of here. They've seen too much. To summarize that, right? They are to exercise a sound discretion on the subject, and it is impossible to define all the circumstances which would render it proper to interfere. But after all, they have the right to order the discharge and the security which the public have for the faithful, sound, and oh boy, I'm not even going to try. I'm gonna leave that one alone. Considious. Okay, I think I got it. Considious exercise of this discretion rests in this, as in other cases, upon the responsibility of the judges under their oaths of office. Okay, thank you for that well put and well quoted statement there. The state has had witness after witness fail to prove the testimony that it would like the jury to hear. Right out the gate, he's not wrong. Shout out to Lil Woody. Rarely in the recent history of Fulton County Superior Court has one party had to impeach so many of its witnesses, including at least the following key witnesses: Trontavia Stevens, Walter Murphy, Archillian Bennett, Eduardo Nava Flores. We've got Adrian Bean, we've got D'Angelo White, and critically, Mr. Ex parte himself, Lil Woody, aka Kenneth Copeland. What is the state to do? Losing its case, apparently unconcerned about the need for public justice. God dang. What is the state to do? Basically, with all this being said, how are they going to fix it? They're clearly losing its case and apparently unconcerned about the need for public justice. The state clearly sought an opportunity to restart the trial by triggering an event in such egregious violation of the constitutional right of Kendrick that he would have no choice but to request a mistrial. Oh my gosh. Now goaded by the state and the actions of Judge Glanville, Kendrick has no option but to move this court for a mistrial to respect the constitutional rights of Kendrick and defeat the ends of public justice. While this trial has been riddled with scores of errors, at least 3 deemed an immediate mistrial. And he's right, y'all. We've seen just from the ex parte meeting, Judge Glanville getting legal advice, them pressuring Lil Woody and meeting with him without his attorney. I mean, we could go down the list. I mean, they lied to Lil Woody in chambers. That's 3 right there. And we're not even getting to the rest of the case. Good Lord. While this trial has been riddled with scores of errors, at least 3 demand an immediate mistrial. First one. Oh, so he's going to list them out for us. Shout out to Mr. Weinstein, man. The Honorable Doug Weinstein. First, placed in an impossible position by the state, this court is faced with the task and requirement to reset this case to at least the afternoon of June 12th, 2024. Interesting. I mean, why would they say June 12th? You would think they would say June 10th because that's when the ex parte meeting took place. But I guess the jury wasn't back in until June 12th, or there wasn't any rulings till then. Is the only reason I could think of. Anyway, he said when Kendrick moved Chief Judge Glanville to recuse himself and improperly failed to halt all proceedings pending determination of recusal. Okay, well, I should have kept reading instead of talking. So basically he's saying on June 12th, that is when Doug Weinstein filed the motion for Judge Glanville to recuse himself. At that point, everything should have stopped and they shouldn't have moved forward until they handled the issue of Judge Glanville recusing himself. But that's not what happened. Since that date, the jury heard days of testimony from Little Woody, testimony that can't be unheard. Whew. Yeah, this is bad. This is bad, bad, bad. Second, Yak Gotti's constitutional rights were violated when neither he nor his attorneys were present at a critical stage of proceedings, the secret ex parte meeting among the state, Chief Judge Glanville, Lil Woody, state investigators, court staff, and deputies. Yep, we know about that. Third, Kendrick's due process rights were violated when Chief Judge Glanville wrongly coerced Lil Woody to testify. Ooh. Yeah, that was a pretty scary situation for Lil Woody, man. Just getting out of jail for the weekend, and then you're brought to the judge's chambers with, thankfully, he knew Kayla, but your lawyer's not there. You don't know what's going on. You haven't been able to be in contact with anyone the whole time. The defense isn't there. It's not right. None of the above three reasons for mistrial would exist absent the state's intention to goad Kendrick into the unfortunate position of having to regretfully request a mistrial. Nah, he ain't. I'm not buying that one. You know he wants a mistrial. I mean, unless they think they can absolutely win. But the state handed them a win on this one. All right, so we've got a little bit of the background. We know the background we just talked about. They had an ex parte meeting on June 10th, right? And then Friday, Little Woody was coerced into giving his testimony. And then we'll keep going through this. Unknown to any member of the defense counsel, the ex parte meeting proceeding was held in Chief Judge Glanville's chambers on this date, and that was June 10th. We just talked about that. Several defense counsel were later made aware of the ex parte proceedings with sworn witness Lil Woody, though not from Chief Judge Glanville nor the DA's office. Shout out to Kayla. Critically, Brady material was disclosed in the ex parte proceeding and withheld from all defense counsel. And Glanville said, I'm not telling you anything, Brian Steele, until you tell me who told you about the meeting. You messed up, Glanville, and you're out of here. Glanville will probably be in the chat at some point. Shout out to him. Following the secret ex parte proceedings on June 10th, 2024, petitioner filed and presented a motion to recuse and accompanying affidavit from Douglas Weinstein to Chief Judge Glanville on June 12, 2024. I'm surprised they didn't put timely in there, a timely motion. The motion to recuse was based on the impermissible secrecy of the ex parte proceedings and violations of the judicial code of conduct that occurred during the secret ex parte proceedings. The motion was summarily denied instanter. That means instantly, I found out, with a formal order issued on June 14, 2024. So basically, again, Glanville said, nope, I'm not even looking at this. I'm not even giving you an opportunity to argue it. And then we saw Brian Steele did his thing. He went to the Supreme Court, and the Supreme Court said, hey, Glanville, you're done. We're going to send this to Ingram. Ingram was like, what? I'm not dealing with this. I'm gone. Ingram gets out of there. Then they said, okay, Judge Rachel Krause, come on in. It's your turn. And we all know what happened from there. We'll talk about it here in a second. All right. On July 1st, Chief Judge Glanville reversed his order of June 14th, saying that he wasn't going to recuse himself, and referred Kendrick's motion to recuse to another judge to determine the merits of Kendrick's recusal motion. On July 15th, Judge Krause recused Chief Judge Glanville. Got him up out of there. But she wasn't happy about it either, though. When we read that in her motion, it was pretty sad. She said Glanville was doing a good job, but you know, I got to take him out of there because y'all are looking at this and are going to think less of the Fulton County judicial system, which I mean, it is what it is. Mistrial is required as all proceedings after June 12th are void. This part is where it gets interesting. The honorable court is now faced with an these words, man. Unviable and impossible task of rewinding this case to the afternoon of June 12th. If a party files a motion to recuse a trial judge and the motion is denied, but it is later determined that the judge should have been disqualified to act in the case, all proceedings after that filing of the motion to recuse are invalid and no effect. Unenviable. Thank you. Unenviable. We got it. Kendrick moved Chief Judge Glanville to recuse during the afternoon of June 12, 2024, and he denied that motion. Critically, Judge Glanville failed to follow USCR 25.3 by not halting proceedings and sending the recusal motion to another judge to rule on the recusal. How can Judge... This is one of the biggest things that bothers me. And I get she's covering herself because it's her coworker. How can Judge Rachel Krause say that I think Judge Glanville would have done a great job continuing to rule on this case fairly when it's clearly pointed out in 25.3, and I think we read 25.1 at one point as well, that Judge Glanville should have stopped the proceedings. Like this is how things are supposed to go. But instead, he's just said, no, we're not going to do it. And we're going to keep moving forward. But she says he was doing a great job. What? Come on, man. I was disappointed in Judge Krause. Honestly, I would have liked it better if she had just let this go on to a higher court and say, no, I'm not going to do anything with it. Let's let the Supreme Court decide. To me, I think it would have been better in her case. It would have looked like she was trying to protect Glanville and then she got out of it. And then we would have, who knows what would have happened after that. But yeah, this is shame on Judge Krause. That's crazy. Subsequently, Judge Krause on July 15, 2024 found that Chief Judge Glanville should have been disqualified. Therefore, under props, don't know what that means. I have to look that up. All proceedings since the afternoon of June 12th, 2024 are invalid and have no effect. So they're trying to erase everything from June 12th moving on, which we kind of talked about, right? The Honorable Court is now saddled with this, with the repercussions of Chief Judge Glanville's failure to follow Rule 25. He should have halted all proceedings as required under Rule 25 and referred Kendrick's motion to recuse for assignment to another judge. Nevertheless, he persisted. Under repeated objections from Kendrick and other counsel, the tainted testimony of Copeland was presented to the jury over the course of 4 days. The remainder of the day on June 12th and June 13th, June 14th, and June 17th. During that time, Chief Judge Glanville, who had been disqualified, repeatedly ruled against Kendrick and other defendants on multiple objections regarding the questioning of Copeland. And we know Brian Steele, of course, had his motion to recuse in there as well. And he called for a mistrial. Now, this court is tasked with unringing the bell. That's a great statement there, because you can't do that. It's impossible. The jury already heard and saw what was going on because we know they're watching on YouTube, right? How is this court to accomplish this impossible task? How does this court take the jurors' notes from these days? Wow. How does this court take the jurors' notes from these days from the jurors? Whoa, that's quite a sentence there. How can the jury unhear days and days of testimony? They can't. This is not a matter of a witness uttering a single statement that a court instructs the jury to disregard. It is neither feasible nor plausible that an instruction to disregard days of testimony can be followed. Yeah, and I think, they mention it here. Instructing someone to not picture flying elephants only results in the listener conjuring images of Dumbo. Oh man. Shout out to Doug Weinstein. That was a nice touch there. A little cherry on top of this amazing motion. Yeah, and he's exactly right. Y'all know, somebody tells you not to look at something or don't think about it, you're going to think about it. It is what it is. And they have notes. They wrote it down. So they heard it. They saw it. They wrote it down. I mean, y'all know if you're a college student, those are the 3 things that you need to hear to actually remember something and make it stick into your brain. So, hey, it's in there. Given the impossibility of erasing the proceedings since June 12th, proceedings that are void due to the state knowingly, improperly requesting Chief Judge Glanville to hold an improper ex parte meeting with the sworn witness, and Chief Judge Glanville subsequently failing to halt proceedings as required by 25.3, the Honorable Court has no alternative but to declare a mistrial. This motion for mistrial would not exist absent the state requesting the improper ex parte proceedings. Simply put, Kendrick was goaded into requesting this mistrial through the state's intentional effort to put Kendrick into this position. So true. Man, this trial is required as June 12, 2024 secret ex parte meeting was at a critical stage and violated Kendrick's rights, right? And thank you to everybody in the chat. I'm going to shout y'all out in a minute. I just want to keep this moving and make sure we get through this because we got a lot of other motions to get through. But Kendrick's constitutional rights were violated when neither he nor his attorneys were present at a critical stage of the proceedings. I wonder if every defendant is going to file one of these. That would be crazy. That would be crazy. Because we already know Brian Steele's doing his thing. He's going to get one up there. Man, the secret ex parte meeting among the state, Chief Judge Glanville, Lil Woody, state investigators, court staff, and deputies. We already know that. Defendants were not provided notice of hearing. Okay, we're kind of keeping with the same theme here. Here, the outcome of the case is substantially affected by the bullying of Copeland into changing his mind regarding testifying. And y'all saw in the transcripts, if you haven't seen the full breakdown of the transcripts, make sure you go and rewatch some of the videos and the live stream that we did, breaking the whole transcript down. You can see this is 1000% too. ADA love, not so much, but Judge Glanville and Simone Hilton, they were definitely making Lil Woody feel like he had no choice but to testify. And they threatened him by saying, hey, if you don't testify, it's Judge Glanville saying this, if you don't testify, I might keep you in there until all the witnesses are heard. And we got a lot of them. So you're going to be here for a minute. Shh. Copeland is the key witness to the state's allegation that Kendrick was involved in the murder of Donovan Thomas, aka Big Nut. Hey, yo. While the case against Kendrick is weak at best, even with the testimony of Lil Woody, without Lil Woody, the state has virtually nothing attached to Kendrick to the murder of Big Nut, which is true. The ex parte meeting with Copeland was thus a critical stage of the trial in which Kendrick has a right to participate. Very well said, man. And I love how specifically Doug Weinstein puts these together because they're very easy to read, very easy to understand and comprehend. And I don't know, maybe some of the interviews and seeing that he's been on social media a lot has changed some of the way he's wording these things, knowing they're going to be read by the public. If that's the case, we got to give that man a round of applause. Thank you. Now, Mr. Weinstein, there's still some words that I'm struggling with, but I'll take responsibility for that. You did your thing on this one. A mistrial should be ordered by this court, given that Chief Judge Glanville denied Kendrick's constitutional right to present at a critical stage of the trial, the ex parte meeting with Lil Woody. Furthermore, the mistrial is a direct result of the state putting into motion the ex parte meeting, knowing that such a meeting would goad Yak Gotti into moving for mistrial. Mistrial is required as Chief Judge Glanville tainted the proceedings by improperly coercing Lil Woody to testify. We just talked about this. Copeland's testimony is tainted by improper meeting prompted by the state, where Chief Judge Glanville wrongly coerced Lil Woody to testify. Chief Judge Glanville's coercion of testimony by sworn witness Lil Woody in the face of Copeland's repeated refusal to testify and Lil Woody's statements that he would lie on the stand was an act of impermissible intimidation and a violation of the Judicial Code of Conduct. I think this is great, and I get that they're saying this because this is a key witness and they'd rather get him out of there. But man, I really want to hear the cross-examination of this so bad, because y'all remember one of the biggest statements that was made, especially by Lil Woody in this ex parte meeting, is, I did these crimes. And even if you look at the transcript, that was completely glossed over by ADA Hilton. She heard that and she said, anyway, Judge, we need to make sure, what are we going to do? Are we going to get him some clothes, or are we going to keep moving forward? She was not having that. Lil Woody said in a transcript, I did these crimes. The defense wasn't even there to address that. Be like, excuse me, sir, you do what now? Hold on. What? Crazy. So I would love to see how a cross-examination would go, but looking at this and seeing all the motions that have come down so far, we're probably not even going to get there. If I had to put my money on it, I would imagine that we're not getting even close to hearing Lil Woody testify again. Kendrick's constitutional rights to due process and a fair trial have been violated by the above actions, and the state actions in working with Chief Judge Glanville over the coercion has intentionally goaded Kendrick into the only possible outcome, this motion for mistrial that should be granted by this court. As a natural result of the state's action, Chief Judge Glanville has violated multiple rules of the Judicial Code of Conduct, the violation of which denied Yak Gotti's constitutional right to due process and a fair trial. I agree. As requested by the state, Chief Judge Glanville held an improper ex parte proceeding conducted with sworn witness Lil Woody. The secret, I forgot about him being the sworn witness too. Jesus. The secret ex parte proceeding was with sworn witness Lil Woody was also a violation of at least section 2.9 of the Georgia Code of Judicial Conduct, which assures every person of a fair hearing. Yeah, and I want to see this too. So y'all bear with me because I want to read through this and just see what it says. Georgia Code of Judicial Conduct 2.9, assuring fair hearings and averting ex parte communication, provides a judge shall accord to every person who has a legal interest in proceedings or the person's lawyer the right to be heard according to the law. Again, here, don't y'all think Young Thug has an interest? Don't you think Yak Gotti has an interest in what's being said in this ex parte meeting? Come on, man. Judge shall not initiate, permit, or consider ex parte communications or consider other communications made to them outside the presence of the parties or their lawyers concerning a pending proceeding or impending matter, subject to the following exceptions. We're not even going to read the exceptions. Do we need to read the exceptions? What? This section A alone tells you everything about this ex parte meeting was wrong. And again, shame on Judge Rachel Krause for saying that Judge Glanville did everything right. This just, if her job and her position and her goal, as she said, by recusing Judge Glanville was to make the public opinion about the judicial system improve, she failed miserably. And Yak Gotti and Doug Weinstein are pointing that out here. Judges shall accord to every person who has a legal interest in any proceeding or the person's lawyer the right to be heard according to the law. Judge Glanville shouldn't have initiated, he shouldn't have permitted, or he shouldn't have even considered ex parte communications or considered other communications made to them outside the presence of Young Thug, Yak Gotti, Brian Steele, Doug Weinstein concerning the YSL trial or Lil Woody's contempt, which is an impending matter. Unless what? Unless there's a circumstance that requires a scheduling. Nope. Unless the judge believes that no party will gain control from being in that meeting or an advantage. Nope. The judge makes provision to promptly notify all other parties of the ex parte communication. They heard it from Kayla. Disgusting, man. Ex parte communications are presumed to have been in error. Likely prompted by the state. Not only did Chief Judge Glanville fail to notify defense Ooh, are they taking shots at Fani Willis? Likely prompted by the state. I didn't miss that, Doug Weinstein. I caught that. Is he talking about Love and Hilton, or is he talking about the lady upstairs? Fani Willis. Ooh. Likely prompted by the state. Not only did Chief Judge Glanville fail to notify. Yeah. Doug Weinstein think he's slick. You're not slick, Mr. Weinstein. I see what you're trying to say. Anyway, not only did Chief Judge Glanville fail to notify defense counsel about the ex parte proceedings as required by Rule 2.9, but Chief Judge Glanville made every effort to conceal the proceedings. Glanville should not have coerced sworn witness Lil Woody to testify. We know that. We'll keep it moving. We got a few more pages to get through, y'all, and then I want to hear your thoughts. As in Webb, the court can't repair the infringement of Kendrick's due process under the 14th Amendment, regardless of whether the violation was under Webb or when. I think, is it when or wine? Y'all have to let me know. Kendrick's rights were violated by the judge's intimidation and coercion of Lil Woody. As the state likely expected, Kendrick has been goaded into seeking a mistrial because of this due process violation and regretfully, all right now, stop the cap, request a mistrial. Wherefore, Kendrick respectfully and regretfully, again, request his honorable court to declare a mistrial based on the particular impossibility of avoiding the case after June 12, 2024, which he laid out and gave some great reasons for. The violation of Kendrick's rights by his being absented at a critical stage of the proceedings and or tainting the testimony of Lil Woody by the improper coercion of his testimony by Chief Judge Glanville. Yeah, Lil Woody said, I did these crimes, and the defense wasn't there. Y'all know they would have said, woo, they had interest. Furthermore, Kendrick respectfully requests this honorable court find that this request for mistrial was goaded by the state when it requested that Chief Judge Glanville hold the ex parte meeting, absented Kendrick from the meeting, and joined with Chief Judge Glanville in the coercion of Lil Woody. This, the 23rd day of July, 2024. All right, y'all, there it is. We got a little bit more information here. This is wild, man. This is wild. And we know there's at least two parties that would be interested in a mistrial. And as Mr. Weinstein so eloquently put it, they regretfully stop the cap, are going to have to request it. And that's Young Thug and Yak Gotti, as we see here. So I don't know what Judge Whitaker is going to do, because again, she's in Fulton County as well. Judge Rachel Krause, she did the right thing, but as you could see, she regretfully did it, and she didn't think Judge Glanville should have been removed. Is Judge Whitaker going to do the same thing? Because just looking at this as someone who is not a legal professional, I think we can clearly see that Glanville messed up in so many ways and really tainted this trial and tainted the jury, which is obviously even worse. So y'all let me know what you think in the comments and in the chat. Is this going to be thrown out? Is there going to be a mistrial? What would you do if you were Judge Whitaker? Let me know.